And each cause number, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review those with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Because there's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Mr. Mora, this is your chance to get your life together. I will tell you, anytime you use drugs, you never know if that's going to be your last time to use. And if you are providing drugs to other people, that's not good either, because you're building your happiness of somebody else's misery. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Judge. May we be excused?
Yes.
Right out of the gate. Notice this, the court isn't moving forward on the original indictment. Instead, they're downgrading the charge to a lesser included offense: assault causing bodily injury in a family setting. That's a huge shift. Question for you. Do you think prosecutors are going soft here? Or is this just strategy because the evidence wasn't strong enough for the bigger charge?
Court is calling 2023 CR 4064, State of Texas versus Michael Martinez. Can I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Albert Chitis for Mr. Martinez.
And are you Michael Martinez?
Yes, Your Honor.
Counsel, have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Martinez, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding on the lesser included assault bodily injury family.
Any objection?
No objection.
All right, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Do you understand the state is proceeding on the lesser included offense of assault bodily injury family as a Class A misdemeanor? Range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, on both.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense. Punishment is to be assessed at 24 days in the Bexar County Jail. There are no applications. There's an affirmative finding of family violence. And if the court follows this agreement, it's the court's understanding that the judgment will be satisfied. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be the entirety of your plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
All right.
Yes,
Did you understand that by signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
State offer states Exhibit 1 and all attachments.
No objection, Your Honor.
Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments and review the same. After reviewing states Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
We are, yeah.
Anything you wish to say on behalf of your client?
Yes, Your Honor. We have a deal for time with the state, and I just want to make sure my client gets full credit for all the time that he's been in county. He's got 255 days here in Bexar County. But in addition to that, he's got 139 days out of Hidalgo County. He was held on.
Boom, there it is. The alleged victim doesn't want him prosecuted. That happens a lot in family violence cases. But here's the twist. The law doesn't always let a victim just walk away from the charges. Why? Because prosecutors argue it's about public safety, not just personal choice. Quick thought for you. Should victims have the final say in these cases? Or should the state step in to prevent potential repeat violence?
At the request of Bexar County. And so he sat 139 in Hidalgo. Then he came here he sat in Hidalgo from June 2nd, 2023 through September 25th, 2023. Then he was booked here and he spent an additional 255 days awaiting trial.
Okay.
Or I should say awaiting the MTR.
All right. And state, have you spoke to the complainant?
We have, Your Honor.
And is she aware of this?
The complainant is not cooperative with our office.
And she did submit an affidavit requesting that he not be prosecuted.
Okay. Anything you wish to say, Mr. Martinez?
Just trying to consider the time that I've already served, in addition to what I owe still on the.
All right. Court is going to find you guilty. There's an affirmative finding of family violence, 24 days in the Bexar County Jail, give you credit for time served. There's to be no contact with Christina Regalado, 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 and the court will find that the judgment is satisfied. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we're going to move on to cause number 2020 CR 10481W, State of Texas versus Michael Benjamin Martinez, showing you what's entitled motion to revoke community supervision and state's motion to supplement pending motion, and state's motion to supplement motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Michael Benjamin Martinez who was placed on community supervision in 2020 CR 10481W for the offense of assault of a public servant, bodily injury on October 29, 2020 for a term of 5 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor, there's an agreement between state and defense.
What allegation are you all moving on?
Violation number 7. On or about the second day of June 2023 in Bexar County, Texas, the defendant, Michael Benjamin Martinez, departed Bexar County without the written permission of the court and or the supervision officer in violation of condition number 7.
How do you plead to that? True or not true?
True.
Other allegations, are you waiving those?
We're waiving waiving and abandoning the others, Your Honor.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 7, the court could find it true, grant the motion, and sentence you to 5 years in the prison? Were you aware of that?
There was 4.
It's 5/5, but we agreed to 4.
No. I'm just,
Oh, sorry, I don't know.
did you understand by pleading true to violation of condition number 7, the court could find it true, grant the motion, sentence you to 5 years in prison? Did you understand that? And up to a $1,500 fine. Knowing that, do you still wish to plead true to violation of condition number 5? Court will find, knowing that, do you wish to plead true to violation of condition number 7?
Yes.
Court will find violation of condition number 7 true. Is there an agreement?
There is, Your Honor,
Yes.
for 4 years, Your Honor.
What are you asking for?
We're asking for 4 years to do as opposed to the 5 underlying sentence.
And that is the case that he actually has the 255 days of credit here in Bexar County and the additional 139 days out of Hidalgo County for a total of 394 days credit.
All right. Was there any restitution in this case?
No, Your Honor.
All right. Then the court will grant the motion and revoke. Are you asking the court to follow the agreement that's been reached?
Oh, yes, ma'am, please.
Are you waiving your right to appeal?
Yes, ma'am. Yes, Your Honor.
All right. The court will grant the motion, revoke, sentence you to 4 years in the prison, give you credit for any time served in Hidalgo County and Bexar County. I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
And you also are not allowed to own or possess any weapons due to your affirmative finding of family violence as well. Do you understand?
Sure.
All right, we can go off the record. You're going to have to do better with your life. You understand?
Yes, ma'am.
And when things are not working out with you with your significant other, you need to just leave. You understand?
Yes, ma'am.
All right, good luck to you.
Judge, I did want to just revisit one thing about the judgment satisfied case. I think you said no contact with Ms. Regalado.
Yes.
In her affidavit, she specifically asked that there be, she was under the impression there was a no contact order and she wanted it removed. So if we could have maybe no harmful or injurious contact.
I understand that you,
My common-law wife, like we've nothing's set in stone with between me and her, obviously, because the whole deal. I understand the severity of everything. The family violence is not to be played with. She's thought long and hard about opportunity with me, and giving me a chance, and deciding, what we should do with the relationship, and we're deciding to work, all this out. But she is in agreement with she really wanted me back on probation, but at the time is I understand, and I have to do the time. We're just trying to work and fix all this. It would just be very strangeful if I couldn't do that. I'm gonna go to prison, so there's no way I'll be able to go to her house and do something evil or whatever like that, whatever the deal is. But we're just trying to being able to reconcile and do all this, contact would really be necessary for that. I go about and take all the classes that I can, and that's what she wants
all
me
right,
to do.
let's see the file on the family violence case, please. I'll allow you to have phone contact with her. That's it.
And she did write on her affidavit,
No, I understand about that, Mr. Martinez, but here's the thing. I mean, you love her, right? She had bruising in the eye. And then I read the report. The report is not good. And I understand that tempers run high, people get in an argument, And then after temper settle down, you know what the cycle is? Person will file an affidavit of non-prosecution. And sometimes cases will get dismissed because the complainant can't be found and they signed an affidavit of non-prosecution. Then you know what ends up happening? We have another assault case and we come back here. Maybe somebody ends up dead. And then guess what people say? Judge, it's your fault. State, it's your fault. Defense, it's your fault. Why didn't we do anything? So the person I have standing before me right now, you have not taken any classes, right? Have you taken any family violence classes?
Yes, Your Honor, when I was on probation.
No, I mean, not just now. I mean,
recent, like
yes.
trying to, I am in line to get into anger management and family violence there at the jail. I volunteered for that myself. It's just that they told me on my kiosk, which I know there's records of that.
Notice how the judge walks a fine line here. She allows phone contact basically for commissary support, but strictly bans face-to-face visits. That's a rare middle ground. Judges usually go all or nothing. What do you think? Is this leniency smart compassion or risky business that could backfire?
Since day one that I got to Bexar County, and Hidalgo County didn't offer any of that. Like they didn't even have church there.
All right.
Out there, so or else I would have gladly, and that's one of the things.
What I'll tell you is I will allow phone contact only because I'm sure she's probably going to want to put money on your commissary books, but there's to be no in-person contact. You understand?
Yes,
and
ma'am.
the phone contact, I'm just allowing it for her, not for you. And I say that because I know she wants to have contact with you. So yes, you will still be able to call her from the Bexar County Jail. She will probably accept your collect call. You probably shouldn't call a lot because that call costs a lot. I'm sure you're going to call her from the prison and she's going to want to accept your call. But I am ordering that there's to be no in-person contact with her. You can only have phone contact with her. You understand?
Yes, ma'am.
All right. Good luck to you.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
Darian De La Rosa. Hello. Hi. Are you all ready to proceed on this?
Yes, Judge. Speak up.
All right, court is calling 2023 CR 4230, State of Texas versus Darian Renee De La Rosa. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense.
Chair of the show from Mr. La Rosa.
All right, and are you Miss De La Rosa?
Yes, Your Honor.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Darian Renee De La Rosa who was placed on deferred adjudication in 2023 CR 4230 for the offense of robbery on July 17, 2023 for a period of 5 years? Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 2, on or about the 9th day of September 2023 in Bexar County, Texas. The defendant, Darian Renee De La Rosa, did then and there admit to using an illegal substance, namely marijuana, in violation of condition number 2.
How do you plead to that? True or not true?
True.
Your Honor, state waives all the violations.
Any objections?
Objection, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Judge. The proposed agreement is for her to go to the DDRF program.
That is correct, Your Honor.
All right, and you're aware of the wait time for DDRF?
Yes, sir.
All right, and I see, even though I'm not going to consider it, there are other allegations in the motion with regards to drug use. So what are we thinking the issue is? Is it mental health?
I think she just goes out and the community judge and hangs on for wrong individuals.
All right, so why are we saying DDRF instead of her going to drug rehab somewhere?
I mean, my understanding was that it was mental health plus drug issues, which DDRF will be able to address.
Okay. Probation? Miss De La Rosa, you guys are recommending DDRF?
Your Honor, that recommendation came from Judge Flynn.
Okay, all righty. Then we'll do DDRF. And then after she completes that, see if they'll accept her back in felony drug court.
Yes, Your Honor.
So the court will deny the motion, altering the main conditions to include DDRF and a referral back to felony drug court after completion of DDRF. Is there anything else?
No, Your Honor.
All right, we can go off the record. Ms. De La Rosa, you're looking at 20 years in prison. Do you understand?
Yes, sir.
And when your counsel tells me the problem is you're hanging out with the wrong people, you know what those people would tell me? That they're hanging out with the wrong people. And I'll say, who is that? And they'll tell me it's you. You're going to have to get your life together. This is serious. You understand?
Yes, sir.
All right, good luck to you. You're welcome.
To address that with the court for reinstatement. And then we're at a plea deadline, and I'd like to ask for an extension of that. May I approach with the documents, Your Honor?
All right, so let's address the case first. What is the reason for discovery? I mean, for extension of plea?
Judge, I think we're here at the plea deadline date. The state has made an offer, and they've invited a counter. So since that offer, we've been working with a counselor. Miss Johnson is 17 years old, and we're working with a counselor to see if there's some mitigation that we can present to the state. So she got picked up last week, and kind of threw a wrench in our plan to get together with the counselor. So I just asked for 30 days to come back, and in the meantime, I'll talk to the state about a counter offer. She's 17 years old, serious charges, and we're just trying to work out the best possible thing we can. So that's where I'm at on that.
All right, Ms. Ferguson.
Yes, sir.
And this will be the last extension for a plea deadline day.
Very well, Judge.
Can I have a 30-day reset on Michaela Johnson?
Judge, can I throw in? I'll be out Thanksgiving week, so.
Oh, as will we.
Mhm.
We will
Okay.
as well. I always try to give the staff extra vacation during the holiday times.
16th of November.
All right, November 16th.
Thank you for that, Judge. And Judge, may we address the bond violation?
Yeah, just one moment. All right, so now the violation.
Judge, I'm trying to understand it. We got notice of it, and I think it went to Judge Angelini, and he remanded Michaela without bond, and she was picked up. So she was, as a result of this case, she was placed in alternative school to her course on Saturday, when she was notified that she did not have to go to school on Saturday.
And here they're complaining about a McDonald's.
Right. So Michaela can answer your direct questions, Judge, but in a nutshell, she thought she could use the time to go pick up food for her brothers and sisters through her father.
All right, and then what is this with Montage Apartments and Marshall's Meadows apartment?
Yes, ma'am. So
I'm gonna have to put you on there. Oh, State, are you prepared to proceed on this?
Yes, Your Honor.
You have, you're asking that she remain remanded, or you all have discussed it?
So we discussed it. I think the state wanted to hear from her specifically as to what happened. And ultimately, I think we were going to be in agreement to allow her back on bond with the understanding that she's not to do these things. But we wanted to make sure this is actually what happened.
All right, can you raise your right hand? You solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes, ma'am.
All right, you can lower your hand, state your name for the record.
Michaela Johnson.
All right, and just one moment. I know Judge Angelini has already ruled upon it, or either. Oh, you know what, actually,
I printed those out for you, Judge.
thank you. All right. To Mr. Hancock. All right, does anybody have any questions?
I'll ask Michaela a few questions if I may. Michaela, you've had a chance to read the violation report. You've explained it to me. I think there's some specific addresses that the judge was going to inquire about. So why don't you just explain to the judge what your decision was once you found out you did not have to attend school?
Yes, sir. Once I found that I didn't have to attend school, I had got a call from my little brother and little sister that they were hungry, and I thought I could use the time. So I went to the apartments to grab money from my aunt. And on the way back, I went to the apartments to ask them what they would like from McDonald's, which is why I was at the McDonald's. And I went back. My Uber took a little longer than expected, which is why I was late home.
Okay. Any questions?
No, Your Honor.
All right, Did her mom want to say anything to
No,
this?
Judge, I think we've addressed it. I just wanted you to know she has the support of her mom and is residing with her mom.
All right. And Stace?
So Judge, I understand what happened in the violation report. It does seem like her story did make sense. That's why I wanted to make sure that the court was able to hear and make a decision based off of what happened. The state's primary concern, again, we heard all this through her attorney, but it's something that I just wanted to make sure, was this the actual thing that occurred? Also to make sure that the court admonished her and made sure that this didn't happen again.
All right. So you're 17.
Yes, ma'am.
You have to realize when you're on GPS, you're only allowed to do what you're allowed to do.
Yes, ma'am, and I apologize.
So the proper thing to have done would have been to pick up the phone, call your pretrial services officer and say, I don't have school today. I just got a phone call from my siblings. They're hungry. May I go to McDonald's? And guess what? They're either going to say yes or no. When you're on GPS, it is not best to ask for forgiveness than permission. When you're on paper, everything is, you got to ask for permission, not forgiveness. Because I think the previous judge taught you that asking for forgiveness after not asking for permission does not work in court. Do you understand that?
Yes, ma'am.
All
Judge,
right.
I think her mom had called Mitchell bail bonds and they would agree to get back on the original bonds if the court would consider that.
All right. If you will call Mitchell bail bonds, because I can't reinstate the bond unless Mitchell bail bonds tells the court they're okay with the court reinstating the bond. So if you get in touch with them today, what I will do is I'll ask that the bond will be reinstated and you have your previous GPS conditions and you're only allowed to go to school.
Yes, ma'am.
You understand?
Yes, ma'am.
All right. So that's not going to happen until I get notification from your counsel that Mitchell is willing to go back on your bond.
Yes, ma'am.
Can I firm that in, Judge?
Yeah, if you want to call them now, you can.
I'll do that.
You're an officer of the court.
All right.
All right, thank you.
Judge.